The Supreme Court's recent intervention in the appointment of vice chancellors in Kerala has reopened an intense debate on judicial overreach, federalism and the role of governors in higher education. On December 11th, the Supreme Court stepped in to resolve the deadlock over vice chancellor appointments at Kerala Digital University and Kerala Technological University. The court directed two search committees, both headed by former Justice Sudhanshu Dhulia, to submit rank lists of candidates. The bench of Justice J.P. Pardiwala and K.V. Vishwanathan said the final appointments would be made by the court itself. This move came after months of disagreement between the Kerala government and the governor, who is also the chancellor of state universities. Earlier, the court had asked that panels prepared by the search committees be sent to the chief minister, who would then forward them to the governor with recommendations. However, the governor later approached the court, arguing that UGC regulations do not allow the chief minister to have any role in the selection process. Despite attempts by state ministers to resolve the issue through dialogue, the governor refused to relent, forcing the Supreme Court to take direct control of the appointment process. At first glance, the court's intervention appears to be a practical solution to ensure that universities do not function indefinitely, do not function under any charge vice chancellors. But this raises two serious concerns. The first is the use of Article 142, which gives the Supreme Court extraordinary powers to do complete justice. While this provision has been used in landmark cases like the Vishaka guidelines, the Shah Banu case and the Bhopal gas tragedy settlement, it is also a double-edged sword. When courts take over executive function, it risks setting a precedent for judicial overreach. This is not an isolated issue. Across Kerala, Tamil Nadu, West Bengal and other non-BJP ruled states, vice chancellor appointments have been stalled for years due to conflicts between governors and state governments. If the Supreme Court begins appointing vice chancellors in all such cases, it raises serious question about separation of powers and whether the court can shoulder such a role given its existing case backlog. The second and more critical issue is that this crisis is largely a result of the Supreme Court's own earlier rulings. In two key judgments, Kalyani Mativanan versus K.V. Jayaraj and Gambhirdhan Gadhvi versus State of Gujarat, the Supreme Court held that UGC regulations would override state university laws, even though higher education falls under the concurrent list. These rulings effectively sideline state legislators and strengthen the power of governance as chancellors. Crucially, the court did not properly address whether the UGC even has the authority to regulate the vice chancellor appointments, since the UGC Act limits its role to maintaining academic standards and not university governance, nor did it explain how subordinate legislation framed by a central body could override laws passed by elected state legislators. Earlier, the Bombay High Court had clearly ruled that UGC regulations on VC appointments were ultra-vires and could not override state laws. But the Supreme Court overturned this judgment without giving detailed legal reasoning. As a result, governors have emerged as the sole authorities in vice chancellor appointments, often bypassing state governments entirely. In Kerala, this has led to the removal of several vice chancellors and the appointment of in-charge vice chancellors without transparent procedures. Ironically, in the current case, the Supreme Court itself has ignored the very UGC regulations it once insisted upon. The court has allowed expert committees to rank candidates by merit, something UGC rules explicitly prohibit, by insisting on alphabetical lists. This contradiction exposes a deeper flaw. While expert committees are barred from choosing the best candidate, the final decision is left to governors who are unelected and need not have any academic background at all. The larger question remains unanswered. Why should an unelected governor, often acting as an agent of the union government, have overriding control over state universities funded and governed by elected state governments? Unless the Supreme Court re-examines its own earlier rulings, questioned that arbitrariness of UGC regulations and acknowledges the politicization of the governor's office. Temporary fixes under Article 142 will not resolve the crisis. If any, the continued erosion of federal principles will only harm universities, students, and the future of higher education in India.